Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. We have been addressing the Idaho Uniform Post-Conviction Procedure Act, the remedy, when a person who has been sentenced and convicted of a crime in Idaho would be allowed to seek post-conviction relief and challenge that sentence and or conviction. The statute is Title 19, Chapter 49. It's Section 194901. And it tells us that there are 7 different categories where any person who has been convicted of or sentenced for a crime and who claims that the conviction or the sentence was a violation of the Constitution of the United States or the Constitution or laws of this state. That is grounds number 1. Number 2, that the court was without jurisdiction, without the legal authority and or power authorized by law to impose the sentence. The third, that the sentence exceeds the maximum authorized by law. In other words, if a person is convicted, sentenced relative to burglary, and a burglary under Idaho law states the maximum is 10 years, and that person has been sentenced to 15 years, that might be an example. Number 3, the sentence exceeds the maximum authorized by law. Number 4, that there exists evidence of material facts not previously presented and heard that requires vacation. That means vacating of the conviction or sentence in the interests of justice. The 5th is that the sentence has expired, that the probation or conditional release was unlawfully revoked by the court in which the person was convicted, or that the person is otherwise unlawfully held in custody or other restraint. Number 6, subject to the provision, it sends you to another section of the Idaho Code, that the petitioner is innocent of the offense, or, and here's the last grounds, 7, that the conviction or sentence is otherwise subject to collateral attack by any grounds of alleged error heretofore available under any common law, statutory, or other writ, motion, petition, proceeding, or remedy may institute without paying a filing fee a proceeding under this act to secure relief. So basically, 7's a catch-all. If what the person is alleging doesn't appear in 1, 2, 3, 4, 5, or 6, here's the catch-all. Number 7, for example, there's some other law out there. There's some other statute out there. There's some other motion or petition that could be filed out there that's not contemplated through the first 6 categories. Now, what needs to be taken into consideration very seriously here is that Mr. Kohberger not just pled guilty, but he signed away his appellate rights in his plea deal. If you look at the plea agreement, page 2, last sentence, you will see there a statement that Mr. Kohberger agreed to waive, to give away all of his appeal rights in exchange for what the government was providing him. And that was essentially that they were taking the DP off the table, because it appears that all of the sentences that he was given was the maximum for each and every one. And we will, of course, advise you, if he does file a document for post-conviction relief, that would have to be a public record, and it would have to show that it is Mr. Kohberger's decision, with the caveat being he understands that if he's successful and his conviction and sentence gets thrown out, what the state's probably going to do is refile, and that could bring the DP back on the table again. That may be something that's going through his mind, or has gone through his mind in thinking about contemplating post-conviction relief. Until next time, this is Kathy. Thank you for joining us here today.